Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with selling a house with the right to request repairs. Easy for me to say 3 times fast. In today's competitive market, this is March 2021, we are finding that a lot of buyers are going under contract here in Georgia with 0 days due diligence. So they're not opting for a due diligence period, but instead they are going in with the right to request repairs. I have touched on this topic in previous videos, but I want to specifically go over this actual exhibit and amendment in depth. So let's back up a little bit. Due diligence period, as you know, is defined as the seller granting the buyer the option or the right to terminate the contract for any or no reason for that negotiated time frame. With the buyer and the seller agreeing in a contract to have the right to inspect, there is no due diligence period. So now during the due diligence period, a lot of buyers may have the home inspected, but this is a completely separate contractual issue. So let's look at this exhibit. This is a Georgia Association of Realtors exhibit. I want to go over the exhibit, the amendment, and a unilateral extension of this right. I want to go over those with you a little bit more in depth. So first of all, let me go over it and then we'll talk about at the end why this might be a great strategy for buyers to have their offer chosen over another offer, and why this might be a great strategy for sellers to accept this buyer's offer with the right to request repairs rather than a due diligence period. So let's look at the forms. So the first form I want to cover with you is the actual exhibit itself, and it is GAR, Georgia Association of Realtors, F273, property sold with right to request repairs. And it absolutely is, I gotta make this bigger. It absolutely is an exhibit. Again, basically, this is in place of a due diligence period. So it says you fill in the offer date and the property address, and it has property sold with right to request repairs. Buyer shall have the right to request that the seller repair and or replace defects, if any, in the property identified by the buyer's inspector or inspectors, plural, in a written report, period. Within X number of days from binding agreement date, let me back up. Well, there are 3 time frames in that. Well, let me just read it. Within X number of days from the binding agreement date, the buyer shall provide the seller with a signed written amendment to this agreement requesting the defects to be repaired and or replaced. B, a copy of all reports of inspectors describing those defects. Now, if the buyer does not timely present this written amendment and inspection reports, the buyer shall be deemed to have accepted the property as is. So that's the first paragraph, the first time frame you negotiate. Paragraph number 2 says, if the buyer does timely submit the written amendment and the accompanying inspection report, the buyer and seller shall have blank number of days from the binding agreement date. Again, another time frame for the buyer and the seller to negotiate. And this time frame is called the defect resolution period, to attempt to negotiate the defects to be repaired and or replaced, sign an amendment to the agreement regarding those issues, and have it delivered to the buyer and the seller. So all that has to be done within the end of this second time frame. If the requirements of the preceding sentence, in other words, if the buyer and the seller don't come to terms on an amendment, negotiating through whatever repairs or replacements need to be done, then if the requirements of that have not occurred before the end of the defect resolution period, then 1 day thereafter, A, the buyer or the seller may accept in writing the other party's last written offer or counteroffer regarding the repair and or replacement of defects, even if that had expired or previously been rejected, it being the express intent of the parties to override any common law of the country. Or B, buyer may accept the property in as-is condition. A final agreement regarding the defects to be repaired and or replaced shall be formed by the first party to give such notice of acceptance to the other party. All parties shall then promptly execute an amendment to the agreement reflecting the accepted offer or counteroffer. If neither party timely accepts the other party's last offer or counteroffer, or if the buyer does not elect to buy the property as is, then the whole purchase and sale agreement terminates. And it doesn't have it in here, but the buyer would get their money back. Then paragraph 3, it goes on to state that if the inspector in the written report recommends any additional tests or studies or inspections or evaluations, then this defect resolution time frame can be, that time period can be extended by the buyer unilaterally with notice to the seller for up to 7 days. Okay, so and then it goes on to say that there's nothing requiring the seller to agree to any amendment. So, and then it goes on to define what an inspector is, what an actual defect is. Let me talk about the defects, and then we'll back up a little bit. So under the definitions, it says the term defects shall mean any infestation by termites, insects, or other wood-destroying organisms, or any condition, building product or item in the property or portion thereof identified by any inspector in a written report, which number 1 is in a condition which represents a significant health risk, including lead-based paint or lead-based paint hazards, or an imminent risk of injury or damage to persons or the property. Number 2 constitutes a violation of current laws, government codes, or regulations, except if it is grandfathered in because it was initially installed or constructed prior to whatever the current applicable laws are. Or 3, if it is not at the present time in good working order and repair, including damage caused by termites, so forth and so on, except other normal wear and tear. All parties acknowledge that certain building products that have been the subject of a class action lawsuit are considered by inspectors to be defective building products, notwithstanding the above, all parties agree that if the existence of a particular defective product has been disclosed by the seller to the buyer in the seller's property disclosure statement prior to the buyer going under contract to purchase the property, in other words, prior to the binding agreement date, then any portion thereof, as the case may be, shall not be considered a defect. So in other words, if the seller discloses, for example, it used to be polybutylene pipes. If the seller discloses that in the seller's property disclosure form to the buyer before they go under contract, then that can't come up. I mean, the inspector is probably going to note it in the report, but that is not something that would be required by the seller to be replaced because they disclosed that defective product prior to that. Okay, so now let's back up a little bit. There are 3 time frames if a buyer and a seller go under contract with the buyer, with the property being sold with the right to request repairs. And the first time frame is, and there is time from the binding agreement date, and it is so many days from the binding agreement date for the buyer to have the property inspected, get those inspection reports from the inspector, and submit the amendment to the seller to repair or replace those defective items as identified by the inspector in that report. That's the first time frame. The second time frame is also timed from the binding agreement date, and that is called the defect repair resolution period. That time frame is the time frame within which the buyer and the seller negotiate the items on this amendment and either agree to the items that the seller is going to replace or repair, or for the buyer to send notice to the seller that they are going to accept the property as is. If none of the second time frame is to negotiate through that. If that amendment does not get negotiated, there is a third time frame. That is 1 day after the defect repair resolution time frame. So if the buyer and the seller do not agree on the amendment and we do not get a fully executed amendment prior to the end of the defect resolution period, the second time frame, then either buyer or the seller have 1 more day to either accept the last offer regarding the repairs that either the buyer made to the seller or the seller made to the buyer, or for the buyer to agree to continue on with the contract, accepting the property as is. If none of that happens within this day after that, then the contract itself terminates and the buyer will get their earnest money back. You still have to do a TNR to release the earnest money. Now, important thing to remember is in this actual exhibit where the buyer and the seller negotiate through these time frames, both of these time frames are negotiated, are timed from the binding agreement date. So the time frame in paragraph 2 needs to be more days than the time frame in paragraph 1. So let's look at this again briefly. It says in paragraph number 1, buyer shall have the property identified. Within blank number of days from binding agreement date, buyer shall provide the seller with the signed written amendment and requesting them to repair or replace the defects along with a copy of the inspector's report. That's the first time frame. They have to send over the amendment with the report. The second one is the time frame to negotiate through all that stuff. And it says buyer and seller have blank number of days from binding agreement date. So again, that number should not be the same, or the buyer would have, if it was 5 days, for example, in both, that means the buyer only has 5 days, have the property inspected, get the report, send the amendment to the seller, and negotiate through through that amendment, all within 5 days. If a buyer wants 5 days to have the property inspected, submit the amendment along with the report, and then an additional 5 days for the buyer and the seller to negotiate through those items, then the fill in the blank in paragraph 1 should be 5, and the fill in the blank in paragraph 2 should be 10. So the second time frame needs to be longer because they have the same starting point. And then the built-in third time frame is if that amendment does not get fully executed prior to the end of the defect resolution period, both parties have 1 additional day to figure out what they are going to do. Now, let's look at, before we go to the amendment, again, it did state that there is the opportunity for the buyer to unilaterally extend the defect resolution period, or that second time frame. But the only way it can be extended is if in the inspector's written report it states that something needs further test or evaluation. So if that comes across in the first report, then the buyer, there is a notice, GAR, Georgia Association of REALTORS, has a form, and it is F276. It is the notice to unilaterally extend the inspection period. And it has a reminder for you guys, it's not to be used when a buyer has a due diligence period. It's only to be used if the buyer goes under contract with the right to request repairs. And again, this can be extended for up to a maximum of 7 days pursuant to the inspector's written report specifically stating that something needs further test or evaluation. And this extension is an allowance for that further test or evaluation to happen. Now let's look at the actual amendment. So this is GAR form F722, amendment to remove inspection contingency. And again, it has a reminder to you guys, this is not to be used with a contract with a due diligence period. This is a completely separate issue. And you reference the date, the properties, and the binding agreement date. And basically it says, pursuant to the terms of the agreement, the buyer or an inspector of buyer's choice has made a diligent, prudent, and competent inspection of the property, and therefore, and in consideration of the sum of $10, we've addressed that in another video, and other valuable considerations paid to each other, the receipt and sufficiency of which are hereby acknowledged. The parties agree to modify and amend the agreement as follows. Number 1, the right to request the repairs contingency set forth in the property sold with the right to request repairs exhibit is hereby deleted. And number 2, the seller agrees to repair or replace in a good and workmanlike manner the following defects on or in the property prior to the closing date set forth in the date of closing paragraph in the agreement. So those are the forms that are used if a buyer and seller go under contract with the right to request repairs. And again, this is completely separate than due diligence. So in the actual purchase and sale agreement, the buyer would, under the due diligence paragraph 8, you're going to put in 0 days due diligence. So there's no due diligence. In other words, the buyer may not terminate the contract for any or no reason. The buyer goes under contract with the seller with this specific right to have the property inspected and request the seller to do repairs. And then depending on the outcome of those negotiations, then the buyer can either accept the property as is or has termination rights under no penalty. So why would this be an effective strategy in this extremely competitive market for a buyer to make their offer 0 days due diligence, but with the right to inspect the property? Well, for that exact reason, because then the buyer, the only termination rights where their earnest money is protected, barring other contingencies. Of course, they may have an appraisal contingency or a financing contingency or sale or lease contingency or other contingencies. But regardless of those other contingencies, they cannot just terminate the contract for any or no reason like a buyer can do when they have a due diligence period. The only way they could terminate and protect their earnest money with respect to this issue is if they have the property inspected, send the amendment to the seller prior to those timeframes we mentioned with the inspector's report, and the seller does not agree to repair or replace whatever items had come across in the amendment based on the report, then the buyer has the option to either proceed or then the buyer could terminate and get their earnest money back. So it is a very, very specific reasons under which a buyer could terminate the contract and protect their earnest money. Whew, that turned out to be a little bit more than I was anticipating, but I think we are seeing a lot more contracts with this rather than a due diligence period to try and make a buyer's offer more attractive to a seller, again, in this highly, highly competitive market that we are in. So I just wanted to go through those forms in the Georgia Association of REALTORS with you, just a little bit more to explain the 3 time frames and potential unilateral extension and kind of how that works. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.